Hi, everybody. Welcome to episode 227 with our wonderful colleague, a regular, Kevin Gregg, who is Kevin A. Gregg. Got to remember that. There's more than one Kevin Gregg, who comes on and talks about all the different federal litigation stuff that's happening, the top cases, which is always really fun and interesting. It's always a very popular episode. Kevin himself has a wonderfully popular podcast that you should definitely subscribe to called Immigration Review, which goes in much more detail than he does here. And it's it's really important to just follow that, especially if you're doing removal defense and dealing with federal court kind of stuff, and especially crimmigration, asylum, humanitarian stuff. There's always a moving target there. But before I start, I want to thank everybody who's contacted me and about the Immigration Lawyers Toolbox magazine. It's a thing I love to do. We finally are getting around to publishing the last one. It's way overdue, but it's going to be coming out probably next week. A lot of ups and downs to get this one out. But I want to thank everybody, especially our main sponsor for the podcast and the magazine, DocuWise, who's always been supportive, who, provides a real service to the immigration community with their software and all the systems they have for office management. And it's just growing with their new updates. Definitely take advantage of them. They have a 10% extra off their annual plan. If you use our code, go to DocuWise.com/immigration-lawyers-podcast. And use the code Immigration Lawyers Podcast, and you'll get that. So it's something that's really good. And, I have a special myself I started for the new year. We had the subscription service for the Immigration Lawyers Toolbox to get all the access to the videos we have, the library and all that kind of stuff. We're opening up that for free for practicing private immigration attorneys. So if you're interested, just email me at info@immigrationlawyerstoolbox.com, and I'll give you access. I'm going to be publishing much more CLEs and everything. I'm just growing my team on the back end so we could publish all the content we have. And so there's going to be a lot of CLE type material, information, guidance, all this kind of stuff to help support the community. And so with that, hey, how are you doing, Kevin?
With that, on to the community. I am the community.
There we go. Hey, community. So how many cases are we looking at today?
Well, first, congrats on all that. As I always say, thank you for your intro of me. As always, it's very much appreciated, and it's humbling. And I mean, you're just doing work, man. Congratulations. That'll be like the whole year on your magazine, right?
Yeah, it finished up the year. And I was thinking about doing once a month, a monthly, but then that was like, oh, that's not going to happen.
Yeah, right.
So quarterly it is. And then try to get
once a month. Get out of here once a month.
I got really excited. I was like, oh, it's so fun. I'm like, oh. I mean, it's really success. My firm is like really just growing, and I was throttling it for years to not let it grow. But then I'm like, you know what? Let's just let it grow and get bigger and higher and all that kind of stuff. So now I'm learning how to do leadership and management and creating systems and all that kind of stuff. Going from a complete solo to, I'm going to be competing with the big ones probably in a couple of years, so if not sooner. So that's the direction we're going.
Fragaman, John Kasravi.
Yeah, JQK JQK U.S. immigration attorneys. Yeah. Bal, be careful. I don't know. Bal is gunning it to be like the biggest out there. They're going hardcore, as Fragment is. And there's other ones. There's one of his name that people don't mention a lot. It's gonna be let me see how long it'll take me to find the name. That Ogletree or something.
Yeah. They're a big firm. They're beyond immigration too, I believe.
They're beyond, but their immigration team is number 3 in size after Fragment. So they're really big. And then Canada's got Ernst & Young, which is accounting, but they have that. And so, but the big 3 in immigration are those 3. But purely immigration, I think Erickson. They have a podcast too, which is on the top podcast. Erickson Immigration Group. They're like, if you just take pure immigration, they're probably number 3 pure U.S. immigration. And they're just growing fast. Their founding partner just passed away, I think last week or something like that. It's unfortunate, but Ericsson's gunning it, and we do a lot of work with them for the Immigration Lawyers Toolbox. They have a global migration experts out in the jam, so we're going to be working on creating some international global migration editions of the Toolbox magazine. I just got to figure out the time, so she's been pivotal in that, and they always have a person at that firm that's helping out with articles. So they have a big team there. They're good on social media and just that kind of stuff. So it matches the kind of stuff I do. Whereas those really big firms, they're like, they want their people to just work. They're like, okay, we'll deal with the marketing ourselves. You guys just work. We got enough business. So it's kind of cool. But yeah, it's an interesting field. I study the entire immigration field, firms and the business side for years now. And a lot of these names, a lot of solos listening, and don't even know about Bowel or Barry Apple and Lyden. They know Fragment because of the thing, but there's a lot of players in this space, and they're all growing dramatically. So there's so much business, really. It just proves that, like, it's just, the pie is huge. And I don't think we're eating a quarter of the pie as immigration practitioners. There's not much more space to do. You just got to tap into it, and for people to know that, hey, there's these services we provide and that we can help you with, and find various cost categories. But that goes into a whole different subject. Let's talk about what you came here to talk about. So what's going on?
Good problems to have, everything you're talking about. And I come on the podcast, your podcast, every month, and I try to talk about the good decisions, because who wants to hear about the bad? I talk about enough of the bad decisions on mine, and I go into a lot of depth. But I'm going to start off with the Board of Immigration Appeals decisions from January, some of them. And, they're all bad. I mean, that's what the board keeps doing. And I'm not saying anything wrong. I'm not saying anything bad, but, the prior administration expanded the Board of Immigration Appeals and then appointed, I think, nearly all of them. And so there's a certain view at the Board of Immigration Appeals. I do believe the current administration has appointed one Board of Immigration Appeals member. Could be wrong, but I think that all these recent decisions are reflecting a certain view of immigration law. And the first two that I want to talk about from January are a matter of Laguerre and matter of Cote. And a lot of this that I'm going to talk about on briefly, in the next 20 minutes is Crimmigration. So I really get into it a lot deeper on my podcast, because you just can't do the 6 minutes per case that I do is already about as abbreviated as you can get. I can't do it in 30 seconds. But what matter of Laguerre and matter of Cote have done, at least as I read it, is the board is using it to create a new precedent that I'm not familiar with before. And that's really in the realm of divisibility. As you might know, for criminal immigration analysis, a lot of it comes down to divisibility, whether the statute is divisible into crimes or one big crime, because a crime can be committed sometimes in a way that doesn't match the definition of a removable offense. For example, a conviction that can be committed through fraud and not fraud, it's not divisible. It's likely not a CIMT. But if it is divisible, then the court can go and look at some documents and see if the non-citizen committed fraud or not. A lot of this analysis comes down to divisibility, and the board and the Supreme Court have been saying to determine whether a statute is actually multiple crimes rather than just one crime, thereby divisible rather than not divisible. State court decisions determining what are the elements of that offense are the most important thing, or definitely one of the most important things. And in a matter of Laguerre, yeah, but not if the state court decision was published in the 80s or the 90s. Then we really look at it hard, and they're distinguishing old state court decisions in those cases. And don't get me wrong, the board is doing a smart job, and what they're saying does make sense in a lot of ways. But I'm also not familiar with any principle that allows them to ignore state Supreme Court decisions that indicate a statute is not divisible, that things are means rather than elements. And this gets deeper into the weeds, and I talk about it on the podcast, but the board isn't even citing to authority either. They're just doing it. So last month they created precedent, and it's for a reason. It might, it seems like it has federalism concerns. I mean, even the Supreme Court defers to state Supreme Court and state appellate court decisions about the elements of state crimes. So it's a big deal. The board did it in January, so I'm bringing it up.
Yeah. So in this kind of situation, I'm guessing this case has to be appealed to federal court to challenge that methodology.
Yeah, and there was a lot of methodologies, a matter of Laguerre and matter of Cote, and maybe they're right, and maybe they're the correct decisions. But what it does is it creates precedent that allows immigration judges and then the board in the future to ignore other state court decisions that maybe aren't as problematic as the state court precedent in Laguerre and Cote. As to Laguerre and Cote, they would have to be directly petitioned to the circuit courts of appeals where the case originated, and I don't know which ones that is. And I don't know who those attorneys are. I don't know if they intend to do so. Mm-hmm. But it's a thing. It's out there. It's the continuous battle that we have over the categorical approach that really all judges seem to hate. And not wrong. I mean, it creates this whole fiction, but it's also it's also immigration practitioners, one of our best tools. Mm-hmm. And the Supreme Court has spoken. Supreme Court hasn't spoken that say that, to my knowledge, that the board can do this. So we'll see what happens. It's interesting stuff. I wanted to bring it to everyone's attention.
I appreciate that. It is important. So what's the next case?
Then there's matter of Laparra. I'm not going to get into it too deep, but essentially it poured a bunch of cold water on the Rodriguez v. Garland decision out of the Fifth Circuit that I had been talking about for many months now, where the Fifth Circuit, maybe a bit surprisingly, held that a notice to appear that lacks the date and time and the location of the first removal hearing, if that led to an in absentia removal order, that case needs to be reopened. And there's a bit more nuance, and the Fifth Circuit came out with a decision after that that kind of qualified that a little bit. But Rodriguez v. Garland was huge for in absentia orders of removal in the Fifth Circuit ever since 1997. I mean, we're talking thousands and thousands of decisions because the Fifth is right on the border. And in matter of Laparra, the board said, we're not doing that. We're not doing that. But they also, but the board based its decision on the statutory text, as did the Fifth Circuit, which means that matter of Laparra, as I read it, is not good law in the Fifth Circuit. But and any other circuit can disagree with matter of Laparra. They don't owe the board any deference. It's not it's not an ambiguous statute. The board didn't say that. The Fifth didn't say that. So this is just a bunch of courts interpreting the statute. We have the Fifth saying one, the board saying the other. We'll see what the other circuits say.
Wow, that is insane. Okay.
But I mean, that matter of Laparra, I don't know. It's a suggestion from the Board of Immigration Appeals, really. No circuit has to, it's the statutory text, but it binds all of the immigration judges everywhere except the Fifth Circuit. That's why the board did it, and the board disagrees with the analysis in Rodriguez. But, you know, it's a circuit split waiting to happen. It's already essentially a circuit split if you count the board as a circuit-ish, because the Fifth Circuit essentially said otherwise. So, I don't know. We'll just be talking about deficient NTAs at the Supreme Court for the next decade.
And probably, if not longer.
After that, I've got, and I'm going to go through it quick. You know, I go through it in depth on the podcast, but there's this Diaz Ortiz v. Garland decision out of the First Circuit. It's an en banc decision, so that's always pretty important. I believe that's the whole court. I believe the only circuit that goes en banc without the whole court is the Ninth, because the Ninth is just so massive that they can do en banc, and it's just a portion of the court. But so I'm pretty sure it's the whole First Circuit, and without getting into it, there was so much. You listen to the podcast, and it's a huge case. But they're really going at this gang database that the Massachusetts police use, and that was used against Mr. Diaz Ortiz to make an adverse credibility finding, to find that he is a member of MS-13, this whole thing. And the First Circuit's really going at this gang assessment database in Massachusetts that I'm sure that police stations have all over the country, saying this is not based on any real evidence. This is not even to be submitted in court. This is just police talking to each other and making notes. This is not something that we can be relying on against Mr. Diaz Ortiz. And it's obviously much more complicated than that, but it seems very interesting because a lot of these cases, if you fear MS-13 as Mr. Diaz Ortiz did, it's the line, does he fear it or is he part of it? You know, a lot of these cases come down to it. And in this case, it's really, really strong on not being able to use just innuendo, even innuendo over and over again, even just because Mr. Diaz Ortiz was regularly hanging out with young Hispanic men who had affiliations with MS-13. It doesn't make him MS-13. And it doesn't make him a liar when he says he's not an MS-13. So there's a lot of good stuff in Diaz Ortiz v. Garland, and a lot of good stuff on burdens that I just don't have the time to get into now, but check out the podcast.
For sure. Yeah, these are important cases, actually. Yeah, now I kind of wish we get to more detail on these, but I know it's complex. I have to listen to the podcast.
This is just January. It's the last five episodes, maybe the last 4 episodes. Yeah, I'm losing count. I'm going on episode 93 of just straight podcasts, and then the special episodes as well. Sticking with the first, to Graca v. Garland. Again, I wanted to stick with the good, right?
Yeah.
And this is back to Crimmigration, and this is about Rhode Island what is it? Rhode Island burglary, I believe. Yeah, Rhode Island, or maybe car theft. I can't even remember at this point. But in this case, it's the First Circuit really applying. It just shows how different courts are doing this categorical approach, crimmigration, so differently. This decision seems unlikely to be published under the current Board of Immigration Appeals. But of course, the First Circuit is a very different entity. Nor does the First Circuit owe any deference to how the Board of Immigration Appeals applies the categorical approach. And in this case, it did something really interesting. Again, it's about divisibility, and it's about whether or not the different ways of committing an offense are elements rather than means. In this case, we've got a conviction that would match the definition of an aggravated felony theft offense. But under matter of ZVS, if a conviction encompasses like stuff like joyriding, temporary taking without the intent to keep it permanently, and I'm paraphrasing, and listen to the podcast for the true non-paraphrasing. If it's going to criminalize joyriding, then it doesn't match the definition of an aggravated felony theft offense. In this Graca decision, the First Circuit said, okay, we're not sure if this statute criminalizes joyriding, but it could, probably, just looking at it. And we can't find any other statute in Rhode Island where this was that does criminalize joyriding. So that means to us that this statute likely criminalizes joyriding. That's very interesting to me. That's not necessarily finding a case. That's not necessarily even the statutory text. It doesn't say, joyriding. It's the First Circuit using the absence of another conviction, another statute of conviction, to say that the statute in front of it is overbroad, that it must encompass joyriding, because we can't find anything else that does. Mm-hmm. That's a pretty powerful crimmigration analysis, depending on your case, as I said on the podcast. And I don't know how applicable it is, and there's a lot more going on in Graca, don't get me wrong, but if you the logic would then go, you've got a case, figure out how it would be overbroad vis-a-vis a removable offense, then look at the whole statutory scheme and find that in the state, there is nothing that criminalizes that overbroad offense. Mm-hmm. And voila, you've got a De Graca type analysis. It's interesting stuff. I love these tools. I love the categorical approach. It's like a big puzzle to me, and I enjoy it a lot. I know that's heady, it's in the weeds, it's late.
I mean, that's where lawyering comes in, and it makes it extra complex. How much does, because I don't practice in immigration court, if you get this really complex stuff, how much does ICE push back or analyze? Because they're overwhelmed with work too. Yeah. Just how do they handle this kind of stuff? We throw this huge memo at them. Do they just not get it too often? Because even the private side lawyers don't have the ability to make these kind of arguments, or how does it play out?
I can't speak for everyone, but if I'm challenging removability, I'm filing a big brief. And not overly big. I'm not doing anything that isn't required. But if it's a particularly serious crime for asylum, if it's just removability, I'm filing a brief. I have yet to run into a crimmigration brief from an ICE attorney that I believe is good. And I know a lot of ICE attorneys. I know a lot of good ICE attorneys. I used to work with a lot of who are now really good ICE attorneys. So it's certainly possible. I think a lot of it probably does come down to the fact that, like you said, I think a lot of it might come down to, like you said, ICE attorneys are, quite overworked as well. But also, there are, some immigration judges are down for these complex arguments. I get the feeling that some immigration judges say, you know what, maybe you're right. I don't like your guy. Let the board decide. Yeah. And if the board affirms me, take it up to the circuit court. See you in 5 years. And that is the reality of what can happen. And I take it back. I must say that in case you do have ICE listeners. A couple of years ago, I had a big fight with in the Atlanta immigration court on a case. I'm not going to get into the details. And the ICE attorney, she submitted some excellent briefs. and it was fun and it was challenging. So I can't say never, I can't say no, but who's got time for this?
Yeah.
I guess I do. We make time, but
I mean,
that's
I
our
would say,
job.
to be fair on both sides of the aisle, there's probably, I would say, a majority probably of immigration attorneys helping on this side don't take the time to do the file of this, and not our friends obviously, but I've been to immigration court. I've sat there. I can't see a lot of those attorneys spending the time to learn these nuances, argue it. It's just not feasible. It's not practical in some cases. I mean, you work for a firm that allows you to do that kind of stuff and gives you the time, and you're into it too.
Well, I'm also speaking to you at 7 p.m. I mean, it's a continuous 13, 14-hour days. And I will say I sympathize entirely, and that's why I do the podcast. I'm trying to give those arguments every week on the cases. But, I mean, also, I strongly believe it's our duty. I mean, if you got to make the argument. It's not, or you don't take the case. And that's what we do. Or you don't play the game.
Yeah, and that's why I don't play the game. I leave it up to you guys. I'll deal with marriage cases.
And on to that, then, very short and sweet. USA v. Gomez out of the Fifth Circuit. This was something I was talking about with other cases before it. It's like a 4-pager. I think Mr. Gomez, I think the Fifth Circuit says he gets drunk at a bar and starts hitting people in the face with a 2x4. I'm pretty sure that's the facts. The facts don't matter because after the Supreme Court's Bourdain decision last year, which was in the Armed Career Criminal Act context, not the immigration context, but the categorical approach applies to both, and these ACCA cases have a crime of violence provision that's pretty much the same as 18 U.S.C. 16A, which is the immigration crime of violence provision. So what happens in cases like Bourdain applies deeply to immigration aggravated felony crimes of violence. In Bourdain, the Supreme Court essentially said a crime with a mental state of recklessness isn't going to be a crime of violence. And, and USA v. Gomez is the direct result. The Fifth Circuit, in like 4 pages, even though the guy got drunk and started hitting people in the face with a 2x4, held that Texas Penal Code Section 22.01A1, which is aggravated assault, is not a crime of violence, overturned itself because the Supreme Court sent the case back to them after Bourdain. And that is because the aggravated assault allows for a recklessness mental state to convict. And it's not divisible. So we're back to divisibility, everything I said. I mean, mental states are rarely divisible. You can do it recklessly, intentionally, knowingly with aggravated assault in Texas, and that makes it not a crime of violence. Is it a CIMT? Because CIMTs often can be done with recklessness, maybe, I don't know, but it's an argument now. It's open. USA v. Gomez. So it's just keeps going, and it keeps someone like me busy as well.
Well, good stuff. Thank you for coming on the show again. We're definitely gonna have you back in next month as always to talk about this stuff. But anything you want to leave our listeners with, obviously check out the Immigration Review podcast wherever podcasts are found. But what's going on with you? Any plans for February now? I know you got a big case you're going to be traveling, more traveling going on in February, or are you going to be stay put in San Diego?
Yeah, no, I'm traveling. I'm going away this weekend for an individual hearing in a state that is having snow. And even though it's WebEx, and I personally don't like the WebEx so much, we still got to prep the witnesses, still got to prep the experts, and a lot of that has to be done in person. So heading off to the snow from San Diego tomorrow.
Yeah.
I like snow's fun for me though, because I just don't. I'm a Florida boy living in California, so it's always unique to me. Yeah, I'm gonna go see my 94-year-old grandma, take a little time off. Awesome. And I'll be dropping a special episode in my podcast feed in the next couple of weeks with fellow South Florida immigration attorney Laura Kelly, who you see online. She's actually the administrator of the Nerdy Immigration Group on Facebook, and she's been doing this Joyful Attorney thing for a couple of months, maybe even a year now. She's a certified, now I hope I get it right. A certified life coach, happiness coach, preventing attorney burnout, and she has her own podcast called The Joyful Attorney. And so I spoke to her earlier this week, I'll be publishing it. It's new, it's different. It's definitely something that I don't usually do. So
you're coming on my territory. It's all right.
I dip my toes a little bit on your territory, but then I come and I pay it forward by talking case law with you. I only dip my toes 4 or 5 times a year, John. 4 or 5 times a year.
That sounds good. Well, appreciate it. We'll probably have her on as well. The Dirty Immigration group is a really excellent group for asking questions. Yeah. I'm on there every day, either asking questions, answering questions, or just reading what's going on. You learn a lot from what's going on in the practice from there. So it's pivotal for immigration attorneys. Even if you don't like Facebook, join Facebook just for these professional groups. And we have a list and links to all of them on the Immigration Lawyers Toolbox magazine. So if they flip through that, go to immigrationlawyerstoolbox.com/magazine. We have a page that lists all these Facebook groups. If you don't know about them, you're just hearing about them, go there. It's a free resource for practitioners. It's definitely something you should use.
No, it's good, and it was eye-opening to me. I don't participate so much, but I certainly, I'm scrolling through and I see something, and I learn every day.
Yeah, it's always something new. Well, thank you so much, bro. It's good seeing you again, Kevin. Have a good one.
You too, John.